You want to say something, Mr. Scrooge?
I did, but all I want to say is that we managed to find for lunch the criminal case that my Lady Hale had mentioned. It's in fact a Northern Ireland case, and we've provided copies to the court. And we think, although I haven't myself yet read it in detail, that the relevant passage is at the bottom of page 11 and the top of page 12.
That is the case I was thinking of. Thank you.
I hope that's of assistance, my lady.
Mr. Allen.
My ladies, my lords, this afternoon I am not going to dive into the case that's just been put onto the bench. I haven't had an opportunity to read it. I hope you'll forgive me if I need to make submissions on that. I shall do so tomorrow rather than now. Now, you will have seen from the timetable that you have the misfortune to hear from me twice, I'm afraid, even though I'm not an appellant in this case. The proposal was that I should have 2 hours this afternoon and an hour tomorrow after the attorney has made his submissions. I'm not sure quite how time will go this afternoon, and I don't think anything will be lost if I run into my hour tomorrow in order to deal with anything that I've not been able to deal with in my friend's case today, because he will have a reply opportunity after that, as does the attorney. So I hope that's acceptable for my lady. I'm working on the basis I've got the time allotted to me, and how I fill it won't matter too much to you as to where it comes, as long as it works for you.
I feel sure you're correct.
Well, all I know is that you'll be timekeeping very, very carefully indeed, as always, my lady. Can I start then by saying that I act, as you know, with Sinead Eastwood for the Commission and for Mr. Lee. And I'm happy to be probed at any point as to where the submissions are those specifically of the Commission as opposed to Mr. Lee. Their interest has been in supporting the legislation as they see that it works, both FITO and SAW, both in supporting it through Mr. Lee's litigation, but also in supporting it in the face of the submissions in the 2 references, which from the Commission's point of view they see as undermining in a very serious way the prohibitions that have been enacted in FITO and SAW. So the Commission's interests go through everything. Mr. Lee, if he's satisfied, if he can uphold the judgments below, is going to be less worried, obviously, about the attorney's references. That's the initial point. What I want to say then is that it's my intention to go fairly closely in accordance with the case that we have put in, which you will see starts in the core bundle at page 3110, MS 3110. And not obviously to read everything out, but to amplify it where it's necessary to do that, to make points of emphasis and to pick up some responses in due course. I want, if I may, to start then by saying that since this is a public hearing of great importance to many people, that both Mr. Lee and Mr. Commission, and the Commission, as we've said in paragraph 6, do not in any sense downplay the importance to Mr. and Mrs. MacArthur of their conscience and their views on same-sex sexual orientation and the biblical concept of marriage. I say that publicly because it's true and it's important. It's not our case that they're not entitled to those views. It's not our case that they are not serious from their point of view. And it's not our case that they're not worthy of respect. And nothing should be said in your judgments, and I'm sure it won't be, but in any reporting of this case, to suggest otherwise. The point about this case is that it is concerned with, firstly, whether there's been a breach of the legislation. Secondly, whether that legislation, in trying to resolve known and understood differences, conflicts, has reached the right answer, or whether judicially you can modify its effect. Now, put in that way, you can see immediately that this is a case that has an interest beyond just the parties. It is concerned partly with the separation of roles within the state, partly with how democratically laws are constructed to deal with difficult issues, and how the effects of those laws in individual circumstances bend or do not bend to human rights, that countervail their impact, and the role of the court in dealing with them. That point, we think, is extremely important, because our submission, as you will appreciate, is that the two courts below have got the law correct, but not only that the law itself, in both Fito and Saw, was the product of deep democratic consideration over a long period of time, involving wide consultation, input at the highest level of human rights bodies, trying to work out how to deal with issues of discrimination on grounds of sexual orientation and discrimination in relation to religion and belief. That is why we have spent a good deal of the case in explaining to this court exactly how these two pieces of legislation came to be made. And in a moment I'm going to take you through some of that, but I'm also going to put it into context by reference to some of the law of this court, recognizing that where difficult issues of human rights arise, the legislature is broadly entitled to draw bright lines, and sometimes there'll be hard cases that arise which seem to be on the wrong side of the bright line, but nonetheless the legislation is to be upheld. Now, before I do that, I'm going to just deal with the gateway issues very shortly, because our submissions in relation to the gateway issues are set out in pretty full form under part 3 of our case, which starts at page 35 on the internal numbering, and it's 3144 in relation to the MS bundle, paragraph 117. We start really setting out, as you have seen already in the submissions from my friend, the context in which there is a limited right to appeal to the Supreme Court. We were chided for suggesting that the Court of Appeal of Northern Ireland is ordinarily the Supreme Court for Northern Ireland. I hardly need develop this submission in front of Lord Kerr, who's a former Lord Chief Justice of this court and will know perfectly well what I'm referring to. But the context of this is that in 1920, in the Government of Ireland Act, Northern Ireland was created. And it was at that point a Court of Appeal for both the North and the South were created. And the Court of Appeal of Northern Ireland is the successor to that court created under the Government of Ireland Act of 1920. And it was intended to have, as it were, the supervisory role with only the most limited control by the Privy Council at that stage. The background, therefore, to these controls on appeal beyond the Northern Ireland Court of Appeal have a long history.
It's all changed in recent times, hasn't it?
In the most recent times, the control is set out, to which we've referred, in Section 42, subsection 6, and, of course, in Article 61.7 of the 1980 Order, which we've referred to in 118 through to 120, in consequence of the 1978 Act, which itself, and if you look at the footnote, my Lord will be reminded of the background to those controls, were the consequence of a considerable internal overview of the way in which these mechanisms should work. Footnote 71 sets out in detail the participants, including the then Sir Robert Lowry, the Lord MacDermott, and the review that was exercised by Lord Gardiner, setting up the review that led to those controls. And it's our submission that when you look at it from that point of view, you can see that the background to this is that there was to be a very limited right of appeal in relation to issues of invalidity as they would have been seen to the participants making the consultation and leading up to the Northern Ireland Act, Judicature Act of 1978, to which we've referred in paragraph 120. Now, we say, on the back of that, that you have to decide two questions. First of all, what is involved in the idea of validity at that point? And then secondly, whether the questions that are raised on the appeal give rise to validity in the sense which is being thought about at that stage. In short, our submission is that what was in mind in the 1978 Act was a constitutional invalidity. If we take the issue of specified enactment, there is no doubt at all that the sexual orientation regulations are not a specified enactment. That is a matter of agreement between the parties and is not an issue. FETO is a specified enactment and is therefore in scope of Section 42, subsection 6. But one has to give weight to the fact that Parliament has not intended that a measure of the kind of the sexual orientation regulations should be treated as a specified enactment. And tempting though it may be, and I can see that it would be enormously tempting to engage with the sexual orientation argument, you must, I suggest in our submission here, respectfully, bear in mind that the legislation has not included the sexual orientation regulations within the class of specified enactment from which there is the potential for a right to appeal. The argument from my friend is that doesn't matter because on the proper construction of Section 42.6, he needs but one point, however small it is, which falls within Section 42.6, to get everything in front of you. Now, he may be right, but I would suggest the consequences of that would be extraordinarily surprising. It would mean that that control could be bypassed by merely arguing on an ancillary point in the Court of Appeal that there was a question of invalidity, whereas the gravamen of the case is something completely different, and the door is open and the matters which Parliament has said should not be the subject of an appeal to this court coattail through with it. If that was the case, what's the point of the control? It's very difficult to see a proper answer to that question.
What is the point of the control, in your view?
My Lord, the point of the control is that this distinguished body have said that there should be limited rights of appeal from the Northern Ireland Court of Appeal.
Well, only in relation to case-stated appeals.
In relation to case-stated appeals, but that's the form in which this appeal took place.
Quite, but
And
that as a species of appeal is very much in the minority of cases considered by the Court of Appeal in Northern Ireland, as I'm sure you will agree.
well, in my experience, for what it's worth, my Lord, dare I say it to you, in cases of discrimination, it's not uncommon that case-stated should be the course that is taken. In practical terms, and as I understand it, the origin of the form of case-stated appeal goes back to the county court and the jurisdiction of the county court, which I should say openly here for those that are not from Northern Ireland or don't understand it, is equivalent to the Crown Court, but wider in Great Britain, and more closely, I think, akin to the Sheriff's Court. It had a civil and a criminal jurisdiction, and has done so. And the Magistrates' Court could have a civil and criminal jurisdiction. And there was an appeal by case stated to the Crown Court, and then in limited circumstances beyond that. But that's about as far as I dare go in making submissions, because the ancient archaeology of the case-stated appeals, I'm afraid, has moved on, as my Lord will know. But that is the background to it. In the wider constitutional context, there's no doubt at all that the Northern Ireland Court of Appeal in the Government of Ireland 1920 Act was intended to be the superior court. You'll have to remember that at that time it was thought that Northern Ireland and Southern Ireland would have something of a relationship akin to Canada, for instance, to England and Scotland.
But in ordinary civil cases, there was a right of appeal to the House of Lords, was there not?
Yes, there was.
There was. So this limited control
I
by
hope
the...
there was, because I participated in several of them.
So this limited right of challenge to the Privy Council was to do with constitutional issues, was it? Not ordinary civil appeals.
My lady, that is right. But if the alternative routes of appeal we have set out earlier in the papers would have involved an appeal to the High Court by way of rehearing, which was, of course, not chosen by the appellants. They chose to appeal by way of case stated, to challenge by way of case stated, accepting the facts as found below, the limited legal constructions in the specific questions in the case stated. So that's the way that it has worked. I'm simply going to say we have to recognise that there is this constitutional control. Whether it's good, bad or indifferent may be a matter of comment, but that it exists is real and cannot be ignored. For what it's worth, there is no temptation involved in your considering some of the issues around the sexual orientation regulations when you come to the Attorney General's references. Obviously, there are very important issues that emerge at that stage. But our submission is that if you are loyal to the text of the legislation and accept the fact that the sexual orientation regulations, as is common case, are not within the scope of these provisions, then it would be wrong for you to engage in an appeal on that part of it. Now, my friend tries to get round that problem by invoking Section 40, subsection 5 of the Constitution Reform Act of 2005, which is a provision which I'm sure this court has looked at on more than one occasion in the past, and usually with the greatest of ease, because usually points of the kind which I've just made don't emerge.
You can just give us a reference to it.
It's Authorities Bundle 5, tab 5, and there's a hot link from page 3147 in the footnote. Is my lord with me?
Authorities tab 5, isn't it? I see.
It's tab 5, which will be bundle
Yeah,
1.
Yeah, then I've got it, yes. Yeah. Yeah. Oh, is that provision, yes.
Yes.
Yeah.
Now, but my lords, once you've got it open, if we can just look at it very shortly, and again, these submissions are not going to go on for very much longer because they are set out in our case. The court has power to determine any question necessary to be determined for the purposes of doing justice in an appeal to it under any enactment. So in order to apply that provision, you must define the appeal that is before you. It's an issue that's got to be resolved in the appeal that is before you. Accordingly, we submit, if SOR is not before you, this is of no use to my friend.
So what happens to the proceedings in respect of SOR, supposing they raise the same issues as the proceedings in relation to FETO, effectively, as one would be left with the position of dealing with one but not the other?
That's the result of the legislation, and that's how it works, and that's it, my lord. Yeah, you may say it's surprising, but this provision doesn't rescue it, if I can put it this way.
Yeah, no, I see your point on this.
It doesn't rescue it. And Lord Reid was acute to this point. In Sternum, we've cited the passage in paragraph 135. In that case in Sternum, which I don't invite you to turn up because it's the fact a million miles away from this case, but there was an attempt to raise a consequential issue in relation to compensation in that case, damages, in the hearing, permission having been refused on that issue. Now, permission having been refused on that issue, there was no appeal on that issue, and Lord Reid said, in that passage we put in the box in paragraph 135, you can't get round that by invoking the provisions of section 40 sub 5 of the Constitution Reform Act 2005. It's a due process.
Mr. Sternum was trying to avoid the impact of an order already made. That's not the same as the appellants in this case.
My point is not to equate facts, my lord. My point is that the reasoning that Lord Reid engaged with was, if there is no permission to appeal on the point is not before the court, and if it's not before the court, the appeal point is not before the court, the issue doesn't arise for determination. You can't use section 40, subsection 5, to go to a place which is not presently before you. You can deal with issues that arise in the course of resolving a matter in front of you, but not otherwise. So, for instance, section 40, subsection 5, permits you to hear argument on issues not raised below. It permits you, if that's appropriate, of course there's a judicial approach to that, but not otherwise. So those are our points on the gateway issues. I'm not going to suggest that there isn't a general public interest in the issues that are raised by this appeal. The number of people that were behind me, both of us, is some evidence of that, and you no doubt would immediately think, whenever there's a conflicts of rights case, that it's likely to have some sort of general public interest. So I'm not going to make detailed submissions on the discretion point on this. It would not be appropriate for us to do that. And indeed, from the Commission's perspective, they want to know how these issues actually interact. But our point is that FITO gets through the gateway, SAW doesn't. And running ahead of myself, I'm going to anticipate something that I will say later on. The FITO case is, we submit, the easier of the two cases to deal with. It's easier because it's clearer. Indeed, we would say it is absolutely 100% clear that the courts below have dealt with it. It doesn't have to engage with issues of association or indeed who believes or holds the different issues. As you will see in due course, the judgment against Ashers and the MacArthurs was on two bases in the County Court. The two bases being that it was the opinion held by Mr. Lee that same-sex marriage should be supported and that that was a political opinion, and it was the objection of the MacArthurs. So both bases, it wasn't merely their opinion that led to the judgment. But I'm getting ahead of myself, and I'm going to open that judgment and make that point to you in due course. So the gateway points have been made. What I want to do next is to frame the context within this legislation is approached. And I want to cite two cases which will be known, the principles will be well known to this court. I've been able to trace that I think every member of this court, with the possible exception of you, Lady Black, so forgive me for not being able to find one for you, have had to engage with the fact, no doubt there is one, but I just haven't found it, that have had to engage with the problem of dealing with legislation which has to make bright lines. There are a number of different places in which this can be seen. One good example to start off with in relation to this is in either Matheson or Carson. Carson's tab 34. I've just picked that up. It's, I think, in the first volume. It may be the second volume. Yes, I've lost the second volume. Have you got it there? Have I got it? Thank you. Carson, at tab 34, is the In Recovery of Medical Costs for Asbestos Diseases Bill case. There's a passage at 54 which I wanted to just show you. Perhaps I can start actually just shortly there. Paragraph 54, that's in
Could I have
the page is 394. This is, includes Lady Hale and Lord Mance and Lord Hodge. And I just want to pick it up shortly at paragraph 54. Perhaps at 53. This was a case in which there was a point about confiscation of property, and you can see it in 53. And then 54, this is in the Welsh legislation. At the domestic level, the margin of appreciation is not applicable, and the domestic court's not under the same disadvantages of physical and cultural distance as an international court. The fact that a measure is within national legislature's margin of appreciation is not conclusive of the proportionality. However, domestic courts cannot act as primary decision makers, and principles of institutional competence and respect indicate that they must attach appropriate weight to informed legislative choices at each stage in the convention analysis. Now, that's in a particular context, but it is a general principle of respect between the different roles that the legislature and the court have. You can see something similar in Matheson, which is in the same volume, in Lord Mance's judgment, page 326, at paragraph 50 and 51. Lord Mance, with whom Lord Reid and Lord Clark agreed, I've had the benefit of reading Lord Wilson's judgment. I found this appeal more finely balanced than he has done, though I've come ultimately to the same conclusion. Courts should not be over ready to criticise legislation in the area of social benefits, which depend necessarily on lines drawn broadly between situations which can be distinguished relatively easily and objectively. I would emphasise this is an important principle in terms rather more forceful than I think Lord Wilson did. In Animal Defenders in the House of Lords, Lord Bingham's speech on this point reads more fully at paragraph 33 as follows. Legislation cannot be framed so as to address particular cases. It must lay down general rules, citation of much authority. A general rule means that a line must be drawn, and it is for Parliament to decide where. The drawing of a line inevitably means that hard cases will arise, falling on the wrong side of it. But that should not be held to invalidate the rule if judged in the round it is beneficial. Now, you'll see that that's a reference to the House of Lords judgment in the Animal Defenders case. And it seemed to us that the court might well be benefit from having a look at what happened to that when it went off to the Strasbourg court. And the Animal Defenders case you'll find in the additional appeal documents. It's tab 12 in the additional appeal documents. The facts can be stated extremely simply. Animal defenders were denied the opportunity by domestic legislation in the Communications Act 2003 to put out advertising on television in relation to their views about the treatment of animals. So
you have to give us a page reference.
I beg your pardon, 4218.
4218, thanks.
So it's a freedom of expression case. I accept immediately that it's a case about a claim to a fetter on a request to positively express, not a case like this, which is concerned with the negative freedoms to express.
Have we got the additional documents electronically?
Well, I do, my lady, and I know they've been created as an electronic bundle.
We do have them on our shared file.
And I can give you a reference. It's the page reference is 4218.
I know, I've written that down, but I didn't have the additional documents on mine.
Are you still struggling, or have you found it?
Well, I've just been given a...
My lady's not struggling at all.
Yeah, it may be that we haven't taken it down from our shared drive onto our laptops then, rather than any other problem. That happened in the earlier case.
I see.
But I also think there is a problem. The electronic form we've been given it in starts renumbering from 1. Yeah. So you can't plug in 4218.
Yeah.
Okay.
It starts at
well, I can
88,
help
I think.
still because I've got it and I can find it for you.
87.
I see, it's 87, is it? Right.
I'm so sorry? I'm told it's page 87.
Yes.
Thank you. I want to just give you, I've given you the outline facts of that. There was a prohibition. Animal defenders wanted to be able to advertise their views about the keeping and exhibiting of primates on TV advertising. and the Broadcasting Advertising Clearance Centre refused to permit this in line with domestic legislation in Section 321 of the Communications Act of 2003. And you've already seen that the House of Lords upheld that rule, notwithstanding it was in conflict with Article 10. There was then a challenge in the Strasbourg court, and the court dealt with it in the matter that I've put in front of you. The passage I want to draw to your attention is the court's approach to deference to the democratic process, which you will find at paragraph 100 on the internal numbering at page 53, on the MS numbering for what it's worth, 4270, but I'm afraid that's going to involve probably some finger pushing in order to get there. Thank you, I'm grateful. 139, I'll write that in. I'm not going to read all of this to you, but the passage of interest starts at 100, general principles. The general principles concerning the necessity of an interference with freedom of expression were summarised in, and then passages from Stoll and Mouvement Raélien Suisse. And the issues of audiovisual media and so on are dealt with in the next few paragraphs. But if you could pick it up at 106, which will be at page 141, we can see here what we submit is going to be the overarching approach that you will take. Whether or not the interference was so pleaded in the above-cited VGT case, the present parties accepted that political advertising could be regulated by a general measure, and they disagreed only on the breadth of the general measure chosen. Now, I don't know if my friend accepts, but I suspect he must do, that there is a good reason for generally prohibiting discrimination in relation to goods, facilities, and services. His concern is to the specificities of this legislation and how it works. It is recalled that a state can, consistently with the Convention, adopt general measures which apply to predefined situations, regardless of the individual facts of each case, even if this might result in individual hard cases. Contrary to the applicant's submission, a general measure is to be distinguished from a prior restraint imposed on an individual act of expression. The necessity for a general measure has been examined by the court in a variety of contexts, such as economic and social policy and welfare and pensions. It's also been examined in the context of electoral laws, prisoner voting, artificial insemination for prisoners, the destruction of frozen embryos, and assisted suicide, as well as in the context of a prohibition on religious advertising. It emerges from the case law that in order to determine the proportionality of a general measure, the court must primarily assess the legislative choices underlying it. The quality of the parliamentary and judicial review of the necessity of the measure is of particular importance in this respect.
Well, that's a particular problem for us.
My lady,
because of Article 9 of the Bill of Rights.
I don't disagree with that, but this is how the approach is taken within the Strasbourg court.
Yes.
If I may read on, the necessity of the measure is of particular importance in this respect, including to the operation of the relevant margin of appreciation. It is also relevant to take into account the risk of abuse if a general measure were to be relaxed, that being a risk which is primarily for the state to assess. Now, I do invite you mentally, as it were, to underpin that, because you will see that's precisely what was in mind in the legislature in addressing the issues that we're going to be looking at in a moment. A general measure has been found to be a more feasible means of achieving the legitimate aim than a provision allowing a case-by-case examination when the latter would give rise to a risk of significant uncertainty, of litigation, expense and delay, as well as discrimination and arbitrariness. The application of the general measure to the facts of the case remains, however, illustrative of its impact in practice and is thus material to its proportionality. It follows that the more convincing the general justifications for the general measure are, the less importance the court will attach to its impact in the particular case. This approach of the court to reviewing general measures draws on elements of its analysis and then it reads on. But that's the paragraph, we say in 108, which should inform your general approach to looking at these two pieces of legislation and is, as I can put it this way, the counterbalance to the obvious force of the argument that Mr. and Mrs. MacArthur feel very strongly about this case. Now, animal defenders has been cited, Your Lordships, in other cases. I made a note of it earlier today. It was cited in Matheson. It was cited to Lord Kerr and Lord Hodge in AB and the HM Advocate last year as well. It's referred to in the judgments in Tigère and in Bank Mellet 2, as well as this one as well. So our submission to you is, this is subject to my lady's point, and I understand that point about the Bill of Rights, which I would respectfully suggest does not arise on this particular case, the approach that defines, if I can put it this way, the respect that you must give to the democratic process in trying to work out how to deal with these issues. And I can add one further point in relation to that. In dealing with conflicts of rights, there is not necessarily one way to do it. You will be looking in due course, no doubt, at the American jurisprudence. And the American jurisprudence shows, as indeed to some extent does the Canadian, that there are different ways of dealing with it. We don't have a First Amendment. We don't have an absolute right to freedom of expression or religion that you find in the First Amendment. We have Articles 9 and 10 and the jurisprudence surrounding them. In some respects, it's a more difficult course that Europe has taken by doing it without that absolute right. Nor do we have a jurisprudence which is as developed of reasonable accommodation that you find in the Canadian Charter. It may be something a court can develop or that the European Court could do, but it's not, as it were, institutionalized in our jurisprudence. And nor do we have, therefore, the same kind of approach to these issues. But that doesn't mean that it is wrong. If it was so, there would have been case law from Strasbourg saying so at some earlier stage. You've only got to look at the references and the footnotes to the cases in animal defenders to see that point. So that brings me to the making of these two pieces of legislation which have got to be applied. And in large part, these have been set out already in the case. But I do want to take you through it. There's a little bit of addition that needs to be made to the submissions that we make. And as I've said earlier, there is some emphasis that I want to make in relation to that as well. This is part 2 of our case, which you'll find at MS 3121. Ordinarily, when I stand on my feet and talk about legislation, there is barely a white paper or an explanatory memorandum that can be referred to. This is completely different. both veto and SAW are the product of deep deliberation and development of the law. One needs to remember, before we go into this, that as of 1975 and 76, discrimination on grounds of gender in the field of the provision of goods, facilities and services was outlawed. In relation to race, it actually goes back probably a decade to the very first race relations legislation, but is reformulated in the 76 Act.
And the remedies weren't the same.
They're not the same, but the rights are developed through that.
In the 60s legislation, they
exactly
weren't.
so. But the point I seek to make about it is this, that the idea that there should be prohibition of discrimination in the field of the provision of goods, facilities and services is now a generation or more old. And it had not been widely extended. It had certainly not been criticised on the basis that there was a major clash with human rights issues in relation to gender or race. But you will need to think in due course, when you mull over the submissions that my friend has made, how easily the religious opinion could be transformed into not an objection in relation to sexual orientation, but an objection to sex. There have been many places in the past where providers of goods, facilities and services have objected in common talk, saying women shouldn't drive cars or shouldn't buy contraceptives. Or, and you could go on and multiply examples of that kind. The kinds of objections that are raised here could occur across the gamut of protected characteristics. Anyway, be that as it may, the way in which it was developed in relation to veto is set out in our case first, because that was the first in point of time. And it's common ground between us that actually this has quite a long history. The 1920 Act itself prohibited discrimination because it needed to, because there was a history of directly discriminatory legislation which prohibited Catholics in the past, for instance, from becoming solicitors, from occupying posts, and so on. And you'll see, therefore, Section 5 tried to start afresh, as set out in the box in paragraph 40. So that was the background, that there was a need to get rid of those prohibitions identified way back then. That led in due course to Section 17 of the 1973 Constitution Act, which is in paragraph 47, which, as we know, applies only in relation to direct discrimination because it says so. I want to just pick up paragraph 48 without opening the text of the 73 Act, because at that stage, the prohibition on legislation being discriminatory was subject to a particular form of appeal to the Privy Council, emphasising again the constitutional nature of the invalidity that is encapsulated in Section 17. And one will see that in Section 48, and you will see the beginning of the discussion about the delivery of services on a discriminatory basis, because Section 19 of the 1973 Act prohibited public bodies from discriminating. And that would include local authorities, for instance, discriminating in the delivery of local authorities' services. So that shows how, as I can put it this way, how important as a social issue within Northern Ireland these developing discussion on the prohibition of discrimination was. over the page, you can see how the 73 Act immediately saw this as a human rights issue, because it was the 73 Act that introduced the Standing Advisory Commission on Human Rights in Section 20, about which we shall hear quite a lot more in due course. And that was a truly expert body, as I've set out in paragraph 52. I don't need to go through its membership. And as I understand it, it has now effectively been merged and expanded under the 1998 Act into the Human Rights Commission. So at that point, we have the beginnings of the discussion about goods, facilities and services, of which we are looking in this context. The real development of individual rights was through the fair employment legislation, firstly in 76, which itself was not subject to review by the Privy Council. That's paragraph 63. And that was less than the protection in the Sex Discrimination Act, or for that matter, the Race Relations Act. And we've explained the way in which that was less. And it became the subject of detailed investigation by the Standing Advisory Committee on Human Rights, as we've set out in paragraph 71 of our paper. I want to just open that to you, if I may, but to point out various different things. First of all, SACA, when it undertook this review of the legislation and what was needed going forward, was acutely aware of Section 17. If you look at footnote, paragraph 73, I point out, and we can show that in the authorities, for your notes, it's at 2770. It actually put into its report on the state of equality law in relation to religion and belief and its extension, it specifically referred to Section 17 and annexed it to its report. The really important part of this is that SACA thought that there was an economic case, an economic well-being case, for making an extension of the goods, facilities and services legislation. We see that, first of all, set out in general in paragraph 72, and we've given the reference, and SACA referred to all the relevant, at that time, international conventions in framing its recommendations. At part 6, it looked at the detail of this, and it may be helpful to pull that up for a moment. It's MS 2771. I'm afraid my computer's just gone on the blink for a second. Which is, I think, in bundle 8. Yes, it is. You'll find the report. The report actually starts at 2752 at tab 126 in volume 8. And the key passage in part 6 is at 2771. Perhaps invite you just to note very quickly, before we get into that, the overall approach, 2762, recognising the international context at 2763, the need for consistency with the UK at 2767, and where the gaps were at 2768, and its detailed consideration of the legislative framework at 2770 at 3.23. The whole of Chapter 6 is important. We've tried to pick out the key passages at 6.2 and 6.4 to 6.5, and indeed to 6.3, which deals with issues of exceptions. And you can see at in paragraph 75 of our case at 3130, where we've set out 6.5, the full analysis of the context of the need to eliminate discrimination in the provision of goods, facilities and services within Northern Ireland as a matter of economic necessity, and indeed more generally as to how it should proceed. And it was careful to consider that exceptions and limitations would be necessary. All of these have been largely adopted in FITO. 77 in our case sets out paragraph 12.47, and you can see the exceptions that are identified there. Discrimination on the grounds of religion, belief, or opinion in respect of provisions should be made unlawful in a similar way to race or sex. There's a sphere of private or family activity which shouldn't be interfered with. It'd be impractical and wrong to attempt to interfere in sales and dispositions by will, use of professional estate agents and so on. The Commission recommends that the same criterion be used to distinguish private from public transactions. Can't interfere with charities. And then 12.53, the Commission recommends there should be a general exemption for religious and political organisations, except in respect of goods, facilities and services offered to the public. And then issues about education and so on. So a really detailed consideration of where the exceptions should lie. There was no legislation immediately in relation to that, but SACA reverted to it in June 1997, that's paragraph 81, and you will find that, and I don't turn it up at the moment, it's tab 123. Principally, that later report from SACA was looking at development of the employment aspects of this. And it gave rise to a white paper called Partnership for Equality, published the following March. And in the white paper, and the timing of the white paper is very important indeed, at 5.42 to 5.55, it said, the existing fair employment legislation is confined to the field of employment discrimination. Comparable legislation on gender and race relations includes within its scope the provision to the public or part of the public. This is a much wider area of social interaction, and SACA has recommended that the fair employment legislation should be extended, and then it's set out. And at 5.44, it will undoubtedly include exemptions, as does the legislations on gender and race, and you'll recognise what is said in relation to that. Now, the date of that was March 1998, a year of great import for Northern Ireland because it was the year which led to the Belfast Agreement. And that agreement took place a month later and expressly referred to this white paper and expressly said rapid progress should be made in implementing the white paper. And you'll see that in paragraphs 84 and 85.
Have you got an electronic reference to the white paper?
I'm sure I have. It's just not jumping off the page at me at the moment. The white paper, I think, is at 2682. I may be wrong. Yes, it is. It's 2682, called Partnership for Equality. The government's... Does my lady have it?
Yes, I do.
The passage at... it's a long white paper. The passage that deals with rapid progress is at 2722. And you'll see it at paragraphs 5.41 onwards. It's what I've set out in the box in my case, but you'll see the passages there. The consultation took place and it closed on the 12th of June 1998, and veto was laid before Parliament in November 1998. Now, we've set out here, in our case, that veto is, of course, an order. But what it did was it repealed statutory provisions in the two Fair Employment Acts and reenacted them with greater force in relation to the employment field, and extended their reach into goods, facilities, and services. It was I barely resist saying this, but it was actually significant in that very important year for human rights that the House of Commons approved veto actually on the day of the anniversary of the Universal Declaration of Human Rights. And you'll see that at the top of page 3135. That was a legislative choice that it should do so at that stage. And the very reason that you get it in an order rather than an Act of Parliament is because veto was designed to be made as quickly as possible. I hardly need repeat the important legislation of 1998, Human Rights Act, Scotland Act, Northern Ireland Act, and so on, all of great constitutional importance. And important though veto is, it didn't quite rank with the Northern Ireland Act and take up parliamentary time. So that's the background to the making of veto. We say you've got to take that into account fully from an animal defender's perspective, from a Carson perspective, Matheson perspective, and so on, and see that really difficult decisions were taken over a long period of time by informed bodies. It wasn't a rush to legislation. It did engage with the major political parties in Northern Ireland, and indeed, of course, the input from the South, in the way that it was formulated, because it features in the Belfast Agreement. And that is why we submit that great deference should be given to the legislative choices that are made within it. So I can take, again, slightly, I'm not sure I can do it any shorter, but I will try to do that. The background of SAW is also set out at some length in our case. Perhaps I can start with the proposition that it was well recognised by the middle of the noughties that sexual orientation discrimination was a very serious subject in urgent need of being dealt with. My lady has referred to it in her judgment in Bull and Bull and Hall and Preddy. Other commentators in other parts of the world have discussed it. You can see it in the jurisprudence of the Strasbourg Court in cases like Varna and, of course, in Gaiden Mendoza. So there was a recognition that the time had come to try and deal with sexual orientation discrimination. It was also recognised that it was difficult, and so it wasn't completely dealt with, in the Equality Act of 2006, which did introduce religion and belief provisions for England, Wales and Scotland, but only introduced powers in relation to sexual orientation for both Northern Ireland and Great Britain. The exercise of those powers was carried out in parallel both in Great Britain and in Northern Ireland, and we've set this out in paragraph 101 onwards of our case, page 3138. And the point of emphasis that we make out of this is the very detailed engagement with the issues that would arise in relation to the interface between religious sensibilities and the discrimination that had been suffered for a long period of time in terms of sexual orientation. The twin track is introduced in paragraph 101. The way it actually worked was that there was a consultation in Great Britain before the consultation in Northern Ireland, but the legislation in Northern Ireland came out before the legislation in Great Britain. And you can see the detail of that in paragraphs 102 and 103. The consultation exercise lasted for 12 weeks, starting in March 2006 in Great Britain, i.e. almost immediately after the 2006 Act had created the powers to legislate in this field. The 8-week exercise for Northern Ireland came after that, ending on the 25th of September. And there were extensive responses. The explanatory memorandum tells us that there were some 375 responses in Northern Ireland. That's in the explanatory memorandum, which I don't think is noted in our case, but can I give you the reference to the two explanatory memorandums to add? Our footnote 61 should have reference MS 4168, and our footnote 62, the explanatory memorandum to SAW 4166.
Oh, well, we're back in the problem, aren't we?
It's in the second bundle. My lady,
which tab?
It's in the additional bundle, and I've now lost that, but Miss Eastwood's going to find it for me. The explanatory memorandum for Northern Ireland is tab 8, and for Great Britain is tab 9.
35 and 37.
Thank you. I don't propose to take you both through the memoranda, but I do invite you to look at them, and there will be some passages which we will need to look at a little bit in the consultation documents. If we can start with getting equal, which is at 826 in the, I think, the main bundle. Oh, that doesn't seem to be right. No, at 4019, apologies. This is the Northern Ireland consultation document. You can see the consultation document. I just put it out, my own version of it. Can you find it for me? Yeah, I think it's in 8. No, that's 7 you've given me. No, I think it's in the big case. Yes, it's in Appendix Part 2, if you want the hard copy document. You can see a wide consultation on all aspects that might arise in relation to that. And then the analysis of the response to it is extensive, and that starts at page 4115. I think I may have understated the number of responses. No, I haven't. Maybe slightly overstated it. 4115, there were then recognised to be 373 responses. By the time of the explanatory memorandum, there were more. And you can see some of the questions that there should be in relation to question 5 at page 4118, consultation on exemptions in relation to dwellings. Question 3 into specific needs, private members clubs, and so on, all the different major areas. And then if you get to page 928, 2 key questions. Do you consider an exemption should be provided from the regulations for some of the activities of religious organisations? Do you agree that these exemptions should be restricted to activities that are primarily doctrinal? If there are any other activities you consider should be covered, what are these? And why do you consider that they need to be exempted? So the open text question on exemptions, and you'll see that there were extensive responses in relation to Christian businesses. So that's sub 3, just below that. And then you get the Northern Ireland office, because it was then exercising the powers of OFM, DFM, a consideration of that under the cross-heading response to the specific concerns raised. I don't read all of that to you, but I do really ask that this court does read from underneath response to the specific concerns raised. And in particular, at page 4122, there's a paragraph that begins, in respect of Christian businesses, and I'll just read that aloud to you because you will see it engages precisely with some of the core components of this litigation. In respect of Christian businesses, again, the government accepts that some people hold very forthright views and do not want to provide a service to some people because of their sexual orientation. Having considered this issue, the government cannot define in law what constitutes a Christian business. The government is firmly of the view that any provision or organisation that opens a business to the public for the purpose of providing goods, facilities or services has to be prepared to accept the public as a whole, no matter how the public is constituted. It would not be acceptable for a hotel owner to turn away a person on the basis of their skin colour, or if they were disabled, any more so than because of their sexual orientation. And then, interestingly, you'll see that the possibility of a kind of freedom of expression is also contemplated. Some respondents argued that people should be able to refuse to drive a car for a couple attending their civil partnership ceremony, or for a photographer to refuse to take pictures of such a ceremony. These regulations do not prohibit people from turning down business from any source, but they do protect all people from having their sexual orientation used as the reason for turning the business down. Government has decided to apply an exemption to the regulations for religious organisations based on that contained in Part 2 of the Equality Act 2006. We believe that this provision, the best solution, to ensuring continuity with existing legislation. And I pause there for a moment just to make a couple of points. That last paragraph on 4122 shows that the approach taken by the government was to try and get correspondence with the exemption approved by Parliament in relation to the outlawing in Great Britain on religious discrimination. Discrimination on grounds of religion or belief. And that is to exempt religious organisations when they're acting as religious organisations in a general sense. So you can see a really detailed consideration, wide consultation, and, if I may say so, at the legislative level, or the administrative level, because this is the executive, some deep thought about the kinds of conflicts that might emerge. Not precisely this one, but a recognition that freedom of expression photographers could be engaged, that religious concerns might be engaged with the relationships between persons of the same sexual orientation who want to engage in the civil ceremony of a civil partnership. We've taken time to go through all of this. I'm not going to read the rest of our case, which shows how this was then reviewed by the Joint Committee on Human Rights, and the legislation on this aspect of it was commended. It is true there is one part of the sexual orientation regulations that took a step too far in relation to harassment, and those have been changed following the Christian Institute litigation in front of Mr. Justice Weatherup, as he then was. But otherwise, as a piece of legislation, they've survived scrutiny of the JCHR, of the process in Parliament. They've been echoed in Great Britain, and they are the product of deep consideration. Now, that really brings me to saying that is the context in which you've got to address the particular problem that arises here. Before I go into the two judgments, which we say have rightly approached these issues, I want to make one short submission about the facts. Understandably, this morning, the effect of this judgment on the MacArthurs, and indeed of this law on the MacArthurs, has been emphasised to you. But it's important also that you see this from Mr. Lee's point of view. These facts are set out in the Statement of Facts and Issues, and they are common ground. He didn't go in there with any abusive intent. He knew nothing at all of the religious beliefs of Mr. and Mrs. MacArthur, and there was nothing whatsoever that might have indicated that to him. He went in and talked to Mrs. MacArthur a few days before he went in to make the purchase, and he was told that he could bring in a logo and it could be put on his cake. He also picked up a leaflet. You have it in black and white, but we've put it on the bench in colour because, frankly, it's much easier to read. And if I may put it this way, you don't understand this case until you see this leaflet. This leaflet shows that Ashers would ice a cake with a witch on it in the top left-hand corner to celebrate Halloween. They'll ice a cake saying, "Happy anniversary, Mum and Dad," or "Happy birthday," I think it's Peter. They'll put the logo of a commercial organisation, City Band. They'll put a picture of Larne Ladies Football Club. They were cross-examined as to whether there was the slightest evidence that they supported Larne Ladies Football Club, to which the answer was not at all. It's not their club. They'll do a happy birthday cake. They'll do a Funky Monkeys cake. They'll put somebody's photograph on a cake. And they say on the reverse of the flyer, we scan images. Bring a favourite photo and we'll scan it using edible ink. For all cakes, we need 3 days' notice. That was what Mr. Lee understood was the offer that they were making to the world at large when he went in with his logo of Burton, Ernie and Support Gay Marriage. There was an attempt to argue that his request was outside the normal offer that they made to the public at large. And that was rejected at first instance and rejected on appeal by the Court of Appeal and is not now before you. What Mr. Lee asked them to do was not egregious. It was not outside the ordinary course of business that they did. It was not a try-on, and it was not an abuse. And I say those loudly now, not merely for you, but because commentators about this case have suggested otherwise. It is not the case that Mr. Lee was doing anything wrong or unusual or strange in bringing in that logo and asking for it to be iced. And he would not have known in any sense whatsoever that it was outside the ordinary course of business for Ashers. It is a fact that Ashers do have terms and conditions and have had some limitations in those terms and conditions. I rather remember that one of them said they wouldn't do nude images, for instance. But there was nothing, and we did look at the terms of the terms and conditions, that suggested that they would not do what he asked them to do. So that's the context of him going in here. And it's also the context, if I may say so, of why the Court of Appeal said that if they were unhappy about where the law bit on that offer, it was open to them to rewrite the offer and to change it. Nobody's suggesting, certainly not me or Mr. Lee or the Commission, that they have to get out of the business of icing cakes. But if there are areas of icing of photographs which they are not prepared to do, and they will not make that offer to the public at large, they're entitled to do it.
Are they? I mean, I would have thought your case would be exactly the same if they'd included a provision which had said we will not ice cakes which advocate same-sex marriage.
I wouldn't have put it like that, and nor did the Court of Appeal.
Well, all right, we'll not ice cakes which express what you submit as a political opinion.
My Lord, they are entitled to say, if they want to, that we don't do political matters, for instance. They could say that. Then, in that case, it's not making any distinction between different classes of political matters, some which they approbate and some which they do not. It's simply saying, we don't do that. We do birthday cakes, we will put commercial logos on, but we don't do politics.
Could they say, we will not ice cakes which are in conflict with our religious belief? With slogans which are in conflict with
that, I think, would be difficult, my Lord, for the reasons that I will adumbrate in a moment when we go through it. Because we submit that if they are operating in the commercial sphere, that would be hit directly on precisely the points that we've seen in the explanatory memorandum here. It's equivalent, if I can put it this way, and these are real problems, to a taxi driver outside here saying that we will not take you to a Catholic church, but we will take you to a Protestant church. because our beliefs are Protestant, not Catholic.
But, I mean, the logic of your situation is surely that if they said, we won't ice cakes which carry any religious belief, that's illegitimate. And similarly, we won't ice cakes which carry any political opinion. Do you say that to be all right or not?
No, we simply say if the commercial activities that they do exclude commercial work in relation to politics, they're entitled to say that. They can disengage from that area of commercial activity.
Aren't they discriminating against people who hold political opinions then in failing to provide cakes?
There's a distinction, my Lord, and perhaps we can be clear about this. The issue wasn't the cake, the issue was the icing on the cake and the graphic on it. That they've always said that he can have a cake of any kind he likes as long as it doesn't have that message on it. And so forgive me if that sounds pedantic, but that is actually the point of difference that lies. But our position is, no, that they're entitled to disengage and say that their commercial offering doesn't do that. They just don't do any kind of political messages, left or right, orange or green, pro or anti the matter of the day. They just don't do politics at all of any kind. That would not be impermissible.
They don't do political issues at all, or religious issues, without specifying anything.
Well, that might be possible if they said they don't do religious issues, or religious or belief issues. We just don't do anything about religion or belief. That might be possible too.
But if religion, I mean, I think in the
No Christmas cakes.
Well, it's a very good question, my lady, as to whether a Christmas cake is a religion or belief cake, and I can see there are difficult issues.
I think the Christians in the room might think it was.
Well, clearly a Christmas cake is something which is a cake that celebrates both a time of year for some people and celebrates the birth of Christ for others. And I do take my lady's point. Perhaps a better example, if I may say so, would be a simnel cake, which has got a more overtly religious element to it because of having the 11 apostles on the top. But our point is that's not for us to do it. It is possible for them to limit their offer. And the fine detail of that may require some further exploration in another case. Fortunately, we're not there on this particular case. I mean, it could be done in a positive way. So, if I can put it the other way around, the vast majority of their work, as we understand it, is to celebrate birthdays and family occasions like 70th anniversaries or that sort of thing. So they could define it, say they do birthday cakes, they could put it in that way. But they do, once they start making a distinction between different kinds of religion or belief, then these issues do arise.
Again, I find this quite difficult because surely you would say it was discriminatory if a taxi driver said, refused a customer, he said, where are you going to go? And the customer said, I'm going to church, or I'm going to worship. And the taxi driver said, well, I don't carry in my car anyone who has a religious belief. I believe religion is pernicious.
We might do, my lord, in that particular situation. That is, and indeed, that's one of the reasons why this case is so incredibly important. Not necessarily specifically that one, but a real problem in Northern Ireland, and in particular in Belfast, is getting a taxi to go, if I can put it this way, into an area which is a unionist part of Belfast. If you've got, and it may be a unionist driver, it may be a Republican driver, but there can be reasons of that kind as well. So the whole point of the legislation is to try and take all the protected characteristics out of the commercial sphere. But our point is slightly different. It is that you can change the offer. Precisely how it has to be done may require quite a lot of further debate. Our present view, and the Commission, is that it could take out it could say no political messages on it. That is our current present view. I do take my Lord's point that you could say that if having no point of view is a protected characteristic as well, that might be discriminatory in that context by comparing the two, because it's advantageous to them and disadvantageous to the other. But the Commission's view at the moment is that that is a possibility. I'll be corrected overnight if I've got that completely wrong, but that's what I understand the position to be. But I do go back to it. This case is not for you to decide exactly how the offer has to be changed on that. I've got now to turn, I think, from this to the way in which the case was dealt with at first instance by Judge Brownlee and then on appeal. And as you'll have seen from our case, we support Judge Brownlee's reasoning. And it's really helpful to turn up her judgment and just to go through that. I'm going to, if I may, deal with the veto point first, although she dealt with it second. I can't now remember which order that it was actually dealt with, but I don't know that that matters very much either. But it's easier to deal with the veto point, I think, first. If you could turn, please, to page 3249. There was extensive pre-action litigation correspondence in this case, and it ended up with a letter of the 31st of July from Hewitt and Gilpin, to which Judge Brownlee referred in paragraph 56, and that reference is MS 3848. I did say in my case I'd turn it up, but I don't think time's going to permit me to do that, and it's probably sufficient to read it here. This was the case that was advanced by Ashers for the reason why the cake was refused with icing. In fulfilling your client's order, our client would have been acting so as to promote and support your client's political campaign, your client's political campaign for a change in the law of Northern Ireland, so as to enable same-sex marriage, which objective is directly contrary to our client's religious faith and conscience. Our client is entitled to refuse to create a polemical message which conflicts with their religious belief and conscience. In a nutshell, that's the case. Now, you can parse that quite simply. The motive is to avoid sinning. The ground is your client supports the message on the cake. It's not difficult. We submit it's utterly straightforward. I am of the view that this explanation why the defendant cancelled the order in itself acknowledges that the third defendant was aware of the plaintiff's support of a political campaign for gay marriage, and that the defendant's refusal to provide the cake was because of their religious beliefs. i.e., it wasn't acceptable to them, and what's more, they wouldn't act on that, as we can see in this, because motive terms, it would involve them sinning.
Is the discrimination against the client, or is it against against the message? Whoever had brought in the cake, supposing a postman or a courier had brought in the picture of the cake, it would have been refused because of the message, not because of who it came from.
Well, no, with due respect. The two are inextricably interlinked. The message was what caused them to be to be motivated to refuse to do it. But they wouldn't have been confronted with the message unless somebody had brought it in.
Well, that's my point. It could have been a courier. They still would have refused
well,
the cake.
then,
they would have
then
said, we
they
don't care who this comes from. We just don't like this message. And it may be being done because it's thought to be amusing. It may be being done by someone who doesn't actually believe it. That's, of course,
but
difficult.
in this case, they actually did think he supported it. And that was the finding of the trial judge. That's what we see, and we'll see it repeated in a moment. So our submission to you is that both grounds, if you look at it from both ends of the telescope, which is my Lord's point to me, actually were addressed by the judge, by Judge Brownlee. But I do take my Lord's point. It could have been a courier and the refusal would have taken place, and then it would have been the message alone. That's my Lord's point. Yeah. But so what? It doesn't matter. It is the ground for their action is that they disliked that particular message. Why they disliked it and why they acted on their dislike are, if I can put it this way, about the forum internum of them. It's their motivation for it. But the simple fact is they disliked the message, and that was the ground for it.
Is that the protected characteristic is the sexual orientation of your client. The protected characteristic is not his entitlement to wage a political campaign.
Well,
that's the distinction he seeks to draw.
Well, with due respect, it confuses several things in that. First of all, this is the Fito case that we are looking at.
We're looking at religious belief.
We're looking at religious belief. And this is a political statement that is being made here, support gay marriage. That is what it is. It is a political cause. Whether or not he's gay is immaterial to that aspect of it. He supports that cause. And the courier, if I can put it this way...
That's not why they object to it. If he said, look, I don't support this, I've just been given £10 to bring the message in, then they would have had precisely the same objection to the message.
But I understand your Lordship's point about this, but it doesn't make any difference. It is a political statement, a political belief that there should be gay marriage, to which they take objection.
Yes.
And that is the motivating force behind their decision not to make the cake.
It's not anyone's particular political belief. It's so to speak, the cake's message, which, if anything, conveys the belief.
As it happens in this case, it was Mr. Lee's case, and the judge found it was Mr. Lee's belief. My Lord, if I may say so, there are two parts to this. In this case, it was Mr. Lee's belief, and they thought it was Mr. Lee's belief, and they objected to it. The fact that it could have arisen in a different way with the courier is neither here nor there. It would have still have been discrimination. The victim might have been different. Mr. Lee may not have known about it. The courier could have taken the cake somewhere else and got the job done somewhere else, and perhaps, or something of that kind. But in this case, it was Mr. Lee, it was his belief, and they objected to the belief. So the motivation, the ground is that that was not a belief that they would act on or share, or they objected to, however you like to put it. And Judge Brownlee worked through these different aspects of it in the paragraphs that followed.
Which paragraph are we on?
Well, we've got to 57. I'm afraid we've got to make some progress with some of this. 59, they sought to argue they didn't know what Mr. Lee's belief was, but they lost on that aspect in 59 and 60. should note in 62 is where she finds the plaintiff was not seeking their support. In 63, the crucial question is to ask why the claimant received less favourable treatment. Was it on grounds of religious belief and or political opinion? Or was it for some other reason? Well, the ground was the message, as my Lord has put to me, Lord Mance has put to me. And then she reviewed all the then present authorities. And I want to emphasise that these are authorities that in some part antedate the making of Feto. Certainly, Mr. Justice Nicholson's case in Northern Ireland electricity is, I think, if I remember rightly, 1980, and Showboat, are capable in their ordinary meaning of covering any cause or reason for an action based on religious belief. Whether the racial characteristics of those of the person treated, the only question in each case is whether the unfavourable treatment afforded to this applicant was caused by racial considerations. In this case, it's political belief considerations. In the Ryder case, the then Lord Chief Justice Kerr, it appears to me clear that discrimination on political grounds can equally be based on the political opinion of the discriminator. If on the grounds of his own political opinion, a prospective employer chooses a candidate on the basis that the candidate's political views are believed to coincide with his own and rejects a candidate whose political views are unknown, that unfavourable treatment can constitute discrimination. I noticed that my friend didn't engage with the Lord Chief Justice, as he then was, on that conclusion, but it's logical that it should be either the view of the individual who suffers or somebody else's, or the discriminators. Frequently in a religion or belief case, or a political opinion, it will be because the discriminator holds strong political views. And if you go back with the Feto explanatory memorandum and all the discussions about that, you can see it is to stop a situation in which one person holding one set of political views won't deal with another who holds different ones.
But in any event, your point is that the district judge held it was also because of the customers.
Belt and braces, which you've then got at 67.
You've got a difficult concept, which is the one you've just been talking about, a less difficult concept. And your point is that she decided on both. She
did. And we get it in 66, 67, all the way through to 69. Now, there is one argument which I haven't got time to develop any length at all, but it is the McConkie case that my friend referred to as trying to undermine this approach, suggesting that it has to be the beliefs of the victim which is in issue. The McConkie case, Lord Justice, I think it was Lord Phillips was dealing with that in the I'm not sure if it's the House of Lords or the Supreme Court, was drawing a distinction in that case between beliefs and actions. And the reason for that is that there isn't protection where political beliefs lead to a particular class of violent action. It's a necessary exception to deal with the specific situation in Northern Ireland, where you can't have people who have violent actions justifying them in the context of Feto as saying it's part of their political opinions. Conkie doesn't help you at all. So that's the Feto case. We say it's an absolutely clear example of an application of the law. All the law was there at an earlier stage, and if I can do this without making Lord Kerr blush, he was entirely right in the way that he put it in Ryder.
More than that to make me blush, I'm afraid.
I shall try.
I have been more than willing to admit that I was wrong on several occasions previously.
But not this one, my lord, but not this one. So we say that's that case. Now, the sexual orientation regulation case is, as I say, requires more analysis. And the reason it requires more analysis is that the conclusion of the judge is unquestionably, and I say that now, although we've questioned it below, but we can't question it now, she concluded that Mrs. MacArthur believed that Mr. Lee was gay, but it wasn't because he was gay that the decision took place. Our case under the sexual orientation regulations was extremely straightforward nonetheless. It was, what was it over which the Ashers and Mrs. MacArthur, if I can put it this way, stumbled in the contract? And it was the word gay. She was cross-examined. Would you have made the cake if it didn't say gay and implied marriage, support marriage, which in Northern Ireland means opposite sex sexual orientation, because there is no same-sex marriage? The answer is it is gay. So once you've identified what is the ground, and if that ground itself is a matter of sexual orientation, which the word gay plainly is, that's an end of it. That is an end of it. That means that the case is established. Subject to these points about whether you have to establish some individual and so on, but we say that is an end of it because the text, the black letter text, says on grounds of sexual orientation. And gay is a sexual orientation word in that context. Absolutely is. It can't be anything else.
It's not there by itself.
That's the point. You're still on this.
No, I beg your pardon, my lord, I apologise.
People can object to the concept of same-sex marriage without objecting to same-sex relationships. You have to look at the phrase contextually.
I don't have a problem with that argument at all, and I'll come back to it. But there isn't any doubt that the specific point in this over which there was objection was the word gay, because that was cross-examined.
Yeah, but it was gay marriage.
My lord, allow me a moment, because that's how we put it in the first place, but it's not where we stopped, because we did run the comparative argument. The judge herself said she didn't think it was necessary to have a comparative argument over this, but this is where there is a point of difference between the appellants and ourselves. Their approach to the comparison is not to test the materiality of the point of objection, which is what we say the comparable approach requires. If you fail when identifying a comparator to take out of the comparison the point over which objection is taken, then you will fail to do the proper analysis for the purpose of the discrimination legislation. The reason they come to the position of saying whoever came forward with this cake, gay or straight, is because they say that the comparison is not about the word gay, the comparison is about the person who comes forward with the cake. But it's perfectly obvious that if you take the word gay out, would you have made a cake from a heterosexual is the way she dealt with it, but it could be from a gay person in this context, which said support straight marriage or support marriage, they would have offered the cake. That is what they would have done. So the key component has to be taken out of the comparison, otherwise the comparison is a useless tool. In Mrs. Shamoon's case, a Northern Ireland appeal, you had to take out of it the fact that Mrs. Shamoon was a woman The issue in the Shamoon case was she was withdrawn from the process of doing personnel assessments of underlings. She was a police officer. And she said the withdrawal of that was because she was a woman. And she failed because she was unable to show evidentially that if she'd been a man, she would have continued doing the assessments. You had to take the gender out in order to do the comparative assessment. And the gender is the relevant protected characteristic. The relevant protected characteristic here is gay sexual orientation. You take that out, you say, would a different result have eventuated? If it would, then you identify that the protected characteristic is the ground of the less favourable treatment. Now, all of this is actually dealt with, as my lady knows, she's heard me on this more than once, in JFS, and it's dealt with in subsequent case law and antecedent case law in Nagarajan and Shamoon and so on, all of which the judge at first instance set out at pages 3241 and 3242. One gets it in Lord Phillips. It's a passage that's quoted always on these issues. What is the relevant factual criteria? And that's the Birmingham City Council case, which also is the precursor to Jameson Eastleigh. In the phrase grounds of discrimination, the word grounds is ambiguous. It can mean the motive for taking the decision. In deciding what were the grounds for discrimination, it's necessary to address simply the question of the factual criteria that determined the decision made by the discriminator. The factual criterion here was gayness. That was it. Supporting marriage was something they were willing to do. Supporting gay marriage, they were not willing to do. Nagarajan, I don't need to cite, well, Lord Nichols's approach to it is there, clear at the top, and so on. So our submission is that all of this was properly analysed below. She also dealt with it on the point of associative discrimination. We said it's not necessary to do that. We said that it can be done simply on the criterion basis. The association basis is very straightforward. It was to meet the argument that there had to be, as it were, somebody who was involved in this, and it's the association with the message with the gay community at large. Now, points are made in arguments saying other people can support gay marriage, and that's perfectly true. And Lord Manser said that the community can possibly benefit from that. But in each of those cases, the benefit to the community at large and the support are associated with only one thing. And that one thing is of importance and relates only to the sexual orientation of being gay. So the benefit to the community at large argument goes nowhere. It's rooted in the fact of sexual orientation, of gay sexual orientation.
But the message certainly isn't rooted in that. The message is one that anyone can support and which the legislature, society as a whole, has.
My Lord, I'm not going to argue against that proposition at all. I'm personally straight and quite happy to support this message, as maybe others in this room are as well. I can take that point entirely. But my point is that when you look at it, what is it that's the component of the message? It is gay marriage. It's not marriage for opposite-sex people. It is marriage between people of a particular sexual orientation. So to say that I support it means no more and no less than I associate with it. It is something which is part of me, and it would be part of anybody else who supported it, straight or gay. It meets the argument that they did not know that, or didn't act on the basis that Mr. Lee himself was gay.
He says that. On that connection, I mean, while we're looking at this aspect, sexual orientation, if one looks at the district judge's actual finding in paragraph 43, it's not related to any belief that the claimant, Mr. Lee, was gay. Her actual finding at 43 is related to the message, a disagreement with the idea of same-sex marriage.
Well, my lord, I understand that point.
Yes.
I mean, we ran it both ways, as you might expect. We succeeded in establishing that persuading the judge that they thought Mr. Lee was gay.
Yes, but we've got to ultimately decide what, on the grounds of what, was the discrimination.
I understand that, and I'm perfectly happy to stake my camp on paragraph 43. I don't have any problem with it at all. They say that the finding is that, she says that the finding that the defence cancelled this order as they oppose same-sex marriage for the reasons that they regard it as sinful and contrary to their genuinely held religious beliefs. Same-sex marriage is inextricably linked to sexual relations between same-sex peoples. Frankly, that's an awful lot of words to say something which is totally obvious. If you say gay marriage, it's marriage between people of same sexual orientation. And that's it.
You said you established, or you got the judge to accept that they believed that Mr. Lee was gay.
We did, but what I was going on to say was she didn't expressly hold that that was the reason. That's why this part of the argument has developed in the way that it has.
You've certainly got the findings that they believed that he supported gay marriage, but you also have a finding that they knew or they believed he was homosexual.
We do, my lord, yes. It is
39.
But I just didn't quite push that point over the margin.
No. So there's a slight disconnect, it might be said, between the findings in relation to sexual orientation and the findings in relation to political opinion and religious belief. In some respects she links them, in some respects she treats them separately.
They are different kinds of prejudice, if that's the right word to use. Objection to somebody because they're gay is not the same as objection to somebody because they believe a proposition that you don't believe in. They are different. And so I wouldn't suggest for a moment that it wasn't open to her to make those different findings, if that's my lord's point to me. Yeah. I'm conscious of the time.
Well, we're just about there.
I know.
Is that a convenient moment, Mr. Allen?
My lady, yes. I haven't dealt with some of the, what I'll call black letter text objections to our argument. And I'm going to have to pick those up, I think, shortly, if I may, in my final hour.
You may use your final hour as seems best to you.
Well, I didn't want you to...
Speaking for myself.
My lady, what I really meant was I didn't want you to get up thinking that I wasn't going to address them. I will.
Good. Well, we look forward to seeing you all tomorrow morning.
Okay.